Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has stated that he's kind of disappointed with Ripple's recent filing, the answer, in which they respond to the allegations put forth by the Securities and Exchange Commission, finally, after a month. And when I say finally, it's just because it's nice to finally see it. I don't fault Ripple for, taking a little over a month to put this all together. This is a monstrous task, and to get a legal team together and make sure on the same page, get your I's dotted, T's crossed, that sort of thing. I don't blame him one bit for that, and I also don't in the least bit blame John Deaton for his bit of disappointment for as far as what's in here. Well, not all of it. It's not that he hates all of it. I'm going to go through and share with you some initial thoughts from it as well as my opinion, but. As a result of what is in this filing, this legal filing by Ripple, in John Deaton's opinion, it makes it substantially less likely that there could ever possibly be a settlement between Ripple and the SEC, which is what we were hoping for up to this point. And I must confess, I've had the same thought. I don't know that I've actually talked about it in any of my videos. I've been processing what's been been going on over the last few days, getting opinions from various lawyers that are willing to talk about this. And I had this question: is it going to be less likely that Ripple would settle now? And I don't think I talked about it in a previous video, but now I got this from John Deaton here, and he's saying, yeah, he doesn't think it's going to be as likely now. And so as far as timeline, what it's going to look like to get regulatory clarity for XRP, I don't know for sure. Won't be surprised if it's over a year, and you'll see why. It just comes down to ultimately this idea of Ripple insisting upon regulatory clarity for XRP. And so if you've been watching some of my videos, you may recall that I've highlighted this concept that the SEC, in their filing against Ripple, they're not requesting a declaratory judgment that XRP be deemed legally classified as a security. And this is of significant importance from a legal perspective because a judge can't declare something that isn't requested. So up until Ripple's filing, what I'd been saying on the channel, and it's based on opinions that I've gotten from all sorts of other lawyers, because I don't have a legal background at all. So there's no way I'd be lost in the woods without any of their help. But to that point, I just thought, okay, XRP can't be deemed a security, because the SEC isn't even asking for it to be declared a security, which to me just illustrated how weak of a case they have. But then you have Ripple, as you'll see in this thread, which I'm about to jump into. Ripple is essentially demanding it. And so, whereas the SEC, under the prayer for relief, they could have requested this declaratory judgment. If you're the defendant, in this case Ripple, there's a section, I think it was called, I could be butchering this, I believe it's actually cited in this thread here, but I just haven't committed this all to memory, but I believe it's called the Affirmative Defense. I apologize if that's incorrect. We'll fix it throughout the video, but that's where Ripple, gets to effectively say what, and this is lay terms, obviously, because I have no legal background, but they get to say what they want. And part of what they want is clarity around whether XRP is or is not a security. And so now we're going to get it. When this is done, look, SEC didn't want that clarity. Ripple wants that clarity. So that tells me SEC feels like they had a weak hand. Ripple feels like they have a strong hand. So that's the good news about this. That's the way that I was initially looking at it. But let me share with you this thread from attorney John Deaton on this is just his initial reaction, having read through this document. Ripple responds. I've been asked to provide my thoughts on Ripple's answer. I quickly looked over the answer late last night. It's 93 pages, and I spent less than an hour reading it over, so please take that into consideration. I plan to review it in much more detail in the coming days, and will likely revisit these initial thoughts. Before I provide any thoughts, I should warn you that if you ask three different attorneys to respond, you are likely to get three different opinions. Also, I always provide my honest assessment, even if it's not what I know people want to hear. Personally, I was disappointed in the answer. My disappointment means nothing and has no impact on the issues. In fact, if this case is going to trial, I would have advised Ripple to answer the complaint much like it did. My disappointment isn't a reflection regarding the skill of Ripple's trial lawyers or in-house counsel, Stuart Alderodi, or regarding the merits of the defense. Ripple's lawyers know much more than I do with respect to securities laws. I'm disappointed because, after reading the answer, I'm less confident that a settlement will transpire within the next 6 to 9 months. Instead, it looks like it may be a very long legal battle ahead. And by the way, actually, in one video, I did make a prediction. It was just a for fun prediction because now it's like I don't know for sure what's going to happen, but I predicted that 6 months after the initial pre-trial get together, which was February 22nd. I was just for fun predicting that there would have been a settlement inside of that time frame. I'm retracting that officially right now. By the way, I'm no longer convinced there's going to be a settlement. But anyway. But that still could ultimately be good for XRP. It's just a shame that things could take longer. Let me continue with the thread here. From John Deaton. Instead, it looks like it may be a very long legal battle ahead. There are 2 ways to write pleadings in court. One way is what's called notice pleading. All you have to do is to provide the minimum amount of information necessary to provide adequate notice of the charges of the defenses. The second approach is what's called fact pleading or evidence pleading. With fact pleading, you provide not all, but a lot of the evidence you intend to rely on to support the charges or the defenses. For example, Ripple's second affirmative defense. There you go. So I got the term right. Yay, go Moon Lambo. And somebody out there is on the fence like, oh, if Moon Lambo didn't get that right, I'm going to unsubscribe. But now he's like, oh, he did get it right. All right, finger off the trigger. There we go. Ripple's second affirmative defense is that XRP is not a security or investment contract. Except for a few sentences in the answer, Ripple doesn't allude to the many examples of use cases demonstrating that XRP is, in fact, not a security. For instance, it doesn't list how XRP is being used as a payroll currency in Japan and elsewhere. Ripple, however, was under no obligation to do so at this stage because all that's required in federal court is to provide notice of your claims and defenses. It's not required to plead some of the evidence that you will rely on at trial. I thought it might be possible that Ripple front-loaded the evidence in an effort to drive home the absurdity of calling today's XRP a security. Strategically, Ripple decided not to go this route. My speculation is that Ripple knew that it wouldn't make any difference to the SEC based on their negotiations and decided to strategically hold information and evidence back to unleash at a more appropriate time later. In short, why show your hand until you're required to do so? No need to give your opponent a heads up on your strategy and arguments. And by the way, I'll pause here just to mention that there's another attorney who I really appreciate sharing information with the XRP community named Jeremy Hogan. And he stated, from his professional opinion, that it looked to him the way that this was written, this document was written, it was in lay terms, effectively, as close as you could in terms of, well, just from a technology perspective. Obviously, it's still, there's all the legalese behind it, but from a technology perspective, it kept it very, very basic. And so if that was indeed done for the judge for some sort of strategic reason, maybe that's it. Maybe it is no more complex than that. That's moving on now. Where did I just leave off? Was it this spot? Oh yeah, here we go. John Deaton continues. This is usually the best strategy to employ when you realize that your case is likely going the distance. There's no doubt that some of the XRP haters will argue that Ripple's answer didn't prove the SEC's allegations wrong and Ripple admitted to certain distributions of XRP. No S-word, Sherlock. Ripple has distributed and sold XRP at times at a discount. That doesn't make it a security. And by the way, let me pause there too. Ripple's been very transparent about that. They are the most transparent company in all of blockchain. There is not even a close second. Think about the Ethereum Foundation. How much Ethereum do they hold? Get back to me when you find out, because they're not telling. Anyway, John Deaton continues. Most importantly, Ripple doesn't have to prove anything yet. The SEC must prove that XRP is a security. All Ripple had to do thus far was answer the complaint. Ripple simply provided notice of a few basic arguments and defenses it will rely on. 1. The SEC lacks the proper authority to regulate XRP. 2. No regulator in the rest of the world claims XRP is a security. 3. The U.S. government has already classified XRP as a virtual currency in 2015 and 2020. Yeah, and so let me pause there too, because there are some people that say, a virtual currency can also be a security. And then I sit there and I listen to that, and I'm just like, okay, So is it also the case that a square can be a circle? Because this doesn't make any damn sense. You've got two different entities regulating it in conflicting ways. How does that functionally work? You can't do that. Look, and this is not my... I don't have a legal background, fine. I'm just telling you, from as logical a position as I can form, that doesn't make a lick of sense. Anyway, let's continue, though. 4, XRP is exempt from the Securities Act because it's the functional equivalent of currency in that it acts as a store of value, a medium of exchange, and a unit of account. 5, it's not a currency. If it's not a currency, then it's a commodity like gold, silver, oil, or Ethereum. Lastly, the SEC should be barred from claiming XRP as a security because it violates fundamental fairness, due process, and fair notice. I find this defense, it's titled as the 4th defense in the complaint, very intriguing. I'm sure Ripple's lawyers will be armed with case law that supports an argument that the government should be stopped from making this claim at this point in time. In a previous tweet, or when I was on the chain, that's another cryptocurrency channel, On the Chain Live, and he was on there a couple times. Or on David Gokhshtein. I never know how to say his last name. I keep forgetting. It's either Gokhshtein or Stein. I apologize. I'm not trying to butcher it. Anyway, in a previous tweet when he was on those, referenced this type of argument by alluding to the doctrine of equitable Estoppel. Basically, that doctrine protects one party from being harmed by another party's voluntary conduct. That conduct may be inaction, or silence, or acquiescence. This doctrine is rarely used against a government entity, and I'm not saying that it specifically applies to this case. I'm only explaining that Ripple's lawyers have encapsulated that concept or doctrine and weaved it into a due process / fair notice argument. Brilliant. Using the 2015 DOJ and FinCEN settlement with their classification of XRP as convertible virtual currency, coupled with the SEC allowing XRP to be openly traded along with Bitcoin and ETH for 8 years, gave any person or company the reasonable belief that XRP would not be prohibited. In short, under the law and circumstances, Ripple lacked a fair notice that its conduct was prohibited. If lawyers are able to provide case law and precedent that strongly supports this argument, they will have the SEC backpedaling during the case. Anyways, these are some of my initial thoughts after the first read of the answer. There is much more to unpack, but that's for another thread. Well done, John Deaton. I love hearing your perspective on all this stuff. Because there's no way I have a handle on this, and I keep saying this every time I put out a video where it's on this topic, but I want to express my appreciation because I would not, and so many others in the community too, the XRP community, would not have a handle on what's going on in the world of XRP and its legal status, and just an idea of where this all might go without people like John Deaton and Jeremy Hogan and others that are sharing their opinions because they actually have legal backgrounds. We'd just be lost in the woods. And, not knowing is what makes this all scary. But at least I'm getting an idea of the direction that things might go and informing ourselves to the best of our ability, even though we don't, most of us anyway, we don't have any sort of legal background. That helps. Because I understand holding any cryptocurrency, including XRP, it's a risk, a calculated risk. And with all the legal nonsense going on right now, I understand it's more risky to hold than it was before all this. But I'm choosing to hold. And it's based on what I've learned just from all sorts of different lawyers and research, what Ripple said. There's just a number of different sources. I've taken all of that, understanding that none of them owe me anything, and I formed my own opinion as an adult. I understand that no one here is my legal counsel, obviously, but still, this is the only way that we lay people can get even just a little bit of an idea of what in the hell is going on here. And so, interesting, but I still remain optimistic. And again, just going back to this idea of SEC not being willing to require some sort of legal declaration that XRP is a security. And then you've got Ripple on the flip side saying, no, we want that. We want not that they want it to be labeled security. They want that regulatory clarity, and they are insisting upon it. Now that is something. That is not something I was expecting. I think everybody was caught off guard by that. And so I can understand the frustration that John's feeling. I get it because I was hoping for a settlement too, and it's probably not going to happen now. But I'm going to stay the course personally, even so. But yeah, absolutely the frustration is warranted. I am not going to get shaken out because of this nonsense. The SEC is ridiculous, but I'll wrap up there. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.